Let's move on to another story. You recently wrote an article for Think Progress on how strip clubs are actually able to exploit dancers because the dancers are technically independent contractors and not employees. Tell us about it.
Yeah, I spent many months working on this report. The strip club industry is not an easy one to report on. There's a lot of secrecy and privacy concerns. But what I uncovered from talking to many different dancers and people in the industry is that there are a number of problems plaguing strippers. One of the biggest ones, though, is that nearly all of them are classified as independent contractors. Think about the fight going on with Uber, for example. It's the same exact fight. Uber says that its employees are independent contractors and that it therefore doesn't directly employ any of them. They just come, use Uber's service, and have their own independent businesses that they run through Uber's app. Whereas a lot of drivers are saying, well, actually, we depend on Uber for setting the conditions of our workplace, how much we can charge, when we can go. That makes them our employer. A lot of dancers are making the same claims. There have been a ton of class action lawsuits against the industry for many years now, all across the country, from dancers who are saying the way that you operate, the way that you control our work means that you are our employer. Strip clubs often set prices, so the dancers who come into the club can only charge a certain amount for each service. They're not allowed to set their own prices. They control scheduling, so they give you shifts. They tell you whether you're day or night. They tell you which days to show up. They penalize you if you show up late. They penalize you if you leave too early, which really is setting the hours and conditions of your employment. Many of them dictate things like uniforms or when you have to get up on stage or if you have to sell certain products. All of this legally should be making these people traditional employees. If you're controlling that much of someone's work, you are their employer. Why this matters is because employers like Uber or like strip clubs get away with a whole lot when they don't have to take on people as traditional employees. They don't have to, for example, pay into unemployment insurance or workers' compensation. They are not liable for sexual discrimination and harassment claims or racial discrimination claims. They don't have to pay the workers minimum wage. In fact, most clubs charge women to come in the door. So the dancers are charged to come in, and then the dancers only make money based on their tips. They're not given any wage at all. They don't have to pay overtime. And so what this means is if you're a dancer, for example, one of the women I talked to was sexually harassed, so she says, in her club by both the customers and her managers and coworkers. She went to file a lawsuit against her club and found out that she is not, because she's classified as an independent contractor, she is not protected by sexual harassment laws and cannot bring it. So in order to bring this case, she has to first prove that she is actually an employee, despite what the club says, and then prove her sexual harassment claim. Both of those are pretty high hurdles. So it's a way for clubs to skirt a lot of costs and to skirt a lot of accountability.
Well, I mean, there are, and from the article, it seems that the Department of Labor rules on employees versus independent contractors are pretty clear, and it does seem, I think in most cases, that theoretically these dancers, under the law, should probably be employees, correct?
Yes, I mean, that's what a lot of people are interpreting. I talked to someone at the National Employment Law Project. She said basically, from what I told her, they sound like they should be employees. The cases that they're bringing have, by and large, been very successful. There was one really significant case in 2009. The Nevada Supreme Court decided against Sapphire's Gentlemen's Club, the biggest club in Las Vegas, saying that its dancers are, in fact, employees and entitled to minimum wage. That said, though, the challenge is that these cases, even when they win, are not having widespread change. All the dancers I talked to on all sides of this issue say, really, conditions have not budged, even with all the victories in these class action lawsuits. Part of that is that, litigation can only go so far. Regulation can go much further. If we actually had the resources at the Department of Labor to go in and inspect these workplaces randomly and make sure they're following the law, that would probably be more effective. The other problem is that strippers are not seen as workers by many people. They operate in in an area of the economy that is rife with stigma, that is seen as something other than an employment area, even though they are workers just like anyone else. They have a lot of barriers to overcome before you even get to the point where you're talking about regulation or widespread change.